Hello and welcome to this third session on the Introduction to Law for the COMP3020 Professional Ethics in Computing module. In this session, we're going to look at specifically the law pertaining to data protection. And the reason I've set this up as a separate lecture is that there is a lot of settled law, there are a lot of principles, and you will, as computer scientists in practice, very certainly encounter questions of data protection. So you need to understand what the legal basis is, what you're allowed to do, and what you're not allowed to do. Before I go into the law, I want to give you a quick overview of what's called the fair information principles. These are principles that were developed in the 1970s when computers became more prominent, and they are principles that were meant to ensure that data is protected and privacy is safeguarded. Now, the reason I think it's worth looking at these is that they're actually reflected in current law, so they're still valid, and to understand the history may help you better to implement them in practice. So the five principles you see here start with collection limitation. That means you can only collect data that you need for the specific purpose at hand. So as a computer scientist, you need to ask yourself the question, do I actually need all the data? Do I need this field? Do I need to ask this question in a sign-up sheet and so on? If you don't need it, you're not allowed to collect it. Secondly, purpose specification. You need to make sure that it's clear what the data is to be used for before you collect it. You can't retrofit your purpose. You need to start by stating and defining the purpose of the data collection, and then you need to proceed accordingly. So that for you raises the question, is it clear in your documentation, in your project plan, what the purpose is? If it's not clear, you're not allowed to collect data. Thirdly, use limitation. Personal data should not be used or disclosed for purposes other than the ones that they were used for or collected for in the first instance, unless you get consent or there is a legal case to be made for this. So that means if you collect your data, are you certain that it cannot be used for any other purposes and that it's clear that it will be used only for the specified purpose to start out with? Security safeguards. So when you collect data and when you hold personal data, you need to make sure that there are the appropriate administrative, technical, physical, and so on safeguards to make sure that the data isn't lost, isn't misused, isn't accessed without authorization. So this is where questions of cybersecurity come in. Do you have the principles in place? Are you working at a good practice level? Do you have encryption? Do you have access control? And so on. And finally, there is the principle of openness and individual participation. So if you collect data about an individual, they have the right to know their data, they have the right to know what it's used for, and they have the right to correct it. So is it clear when you develop a system how that's going to work? How do people get access? Who do they have to ask? How can they rectify mistakes? Now, all of these, as you will see in a minute, are relevant to current law. There are various bits of legislation out there that govern data protection. The primary one is the GDPR, the General Data Protection Regulation, which is a European piece of legislation, but there is a UK version of that that was implemented before the UK left the EU. So there is the UK GDPR, which is complemented by the Data Protection Act 2018, which governs the use of data in this country. There are lots of other bits of legislation out there. There's Council of Europe, the Convention 108. There is human rights law, which is also applicable in this country. So there's the European Convention of Human Rights, there's the Human Rights Act. And then there are applications of the GDPR outside of Europe as well. So for example, if you want to process data from European subjects, you will be subject to the GDPR, even if you do that in India or China or wherever else. And then looking at the US, because of the legal system of the United States, there is at this point no general agreement on the principles of data protection, but you have lots of legislation in the different states. They vary, but some of them are quite strict in terms of data protection. So the GDPR is what drives us here. It applies to the processing of all personal data. So what do we mean by processing? Anything, any operation or set of operations which are performed on personal data. And what is personal data? Well, personal data is any information that relates to an identified or identifiable person. And that's the identifiable is important because even if you do not collect data such as names or addresses, you may still be able to identify people. And that means it will count as personal data and be subject to the GDPR. So what is identifiable? This is recital 26. The recitals are sort of the explanation of the law that have been written by the Parliament. And recital 26 says that identifiable is if anybody can identify a natural person using any means reasonably likely to be used. What is reasonably likely to be used? Well, that's a potentially difficult legal question, but if it is possible to combine, for example, the data you collected with another database and thereby use other available data to identify an individual, then that data that you collected would be considered personal data. So there are different types of personal data or different categories that you will easily recognize. So if you have a name, that's obvious. You can identify who it is, but many others are similarly obvious. Their telephone number, their email address, if they have an identification number, a bank number, whatever it might be, a human resources account. But then there are also data which are sort of a step removed, but which may be used to identify, like location data, who was when, where, IP addresses, which of course link to a computer, but if it's a personal computer, then you can simply find out who owns the computer and you can identify the individual. So all of this would count as personal data. On top of that, and requiring further protection, is what's called special category personal data. These are personal data that the law defines as particularly sensitive and that you need specific reasons to process and which need to be protected to a higher level. So you can see the ones that are there. This is personal data about racial and ethnic origin, political opinions, religious or philosophical beliefs, trade union membership, genetic data, biometric data, health data, and data concerning sex or sexual orientation. So whenever you touch on any of those, you need to make sure that you comply with the principles of processing special category data. So here are the 6 principles of the GDPR to ensure accountability, and you will recognize the fair information principle in those. So firstly, there's lawfulness. You have to make sure that the data is collected and processed in line with legal regulations, and you have to have a legal basis. There's the purpose limitation, same as I talked about earlier in the fair information principle. You can only use it for the purpose it was collected. There's the data minimization. You must not collect data beyond what you need. There's the accuracy. You have to make sure that the data is correct and that people find ways of or have ways of rectifying if there's a mistake in the data. There's a storage limitation. That means you cannot use it any longer than you need it. So the question then is, how long do you need it? That's something you need to think about before you collect the data. And then finally, there is integrity, making sure that the data is not lost, is not disclosed without authorization. So these are the legal principles of the GDPR, which come directly from the fair information principles. So what's required? You have to have a legal basis for processing, and I'll come back to that in the next slide. There are certain things you can do to ensure that you protect the data, that the data is being dealt with lawfully, and these are, for example, and can include data protection impact assessment. Again, I'll come back to that in a minute. You may need to anonymize data, pseudonymize data. There may be a need for encryption. There may be a need for access control measures in all sorts of physical or electronic ways. So there are many, many different measures that you may have to implement. And then if you want to exchange data with other partners, with other organizations, then you need a data use agreement. You need to potentially data transfer agreement, data controllership agreement. So there needs to be a legal basis that very clearly defines what the data exchange principles and practices will be. So what's the legal basis for processing? There are 6 legal bases in the GDPR. The first one is consent. Consent means that the data subject has a clear understanding of the purpose and then agree out of their own volition that they are happy with the data to be processed. Secondly, there may be a contract that's necessary. So it's necessary for you to process data because you have a contract with the individual. You want to provide a service for them. They enter this contract, and then you have the right to process the data accordingly. Legal obligation. So it may be that you have to process the data because the law requires you to do so. There's vital interest, which is necessary to protect someone's life. So you may, for example, be allowed to check somebody's medical record when they've had a heart attack or they need an operation, because it is something that will help you save their life by giving the right blood type or whatever. So that would be justifiable. There are public tasks. So if the use of the data is done with a view to the public interest or an official function, and if it's necessary by law. Think of handling personal data for tax purposes. People might not consent to that, but it's still necessary. There is a legal basis, and you can do this. And then finally, there is the legitimate interest basis. So the processing of the data is necessary for your interest, unless there's a good reason to protect someone's personal data. So if you can make the argument that you have a legitimate interest, then you may be able to process data accordingly. So one of these legal bases must always be in place, at least one, and maybe more than one, but you must have one of these legal bases. For some types of data, for special category data, you need additional principles. So for the 6 examples or the 6 legal bases for data processing that we've just looked at, according to Article 6, if you want to go for special category data, you need additional legal bases under Article 9. And then if you want to process criminal offense data, it goes even further. You need another legal basis in order to do that. When you process personal data, you need to make sure that you comply with the principles of the GDPR. But as I said earlier, it's not just the GDPR that's out there. There are other bits of legislation and regulation that you need to comply with. One is the Privacy and Electronic Communication Regulation, which I'll talk about at the end of this lecture. And then there are others, such as common law duties of confidentiality, or Human Rights Act, Article 8, which covers privacy. So to keep in mind, you need a legal basis, and you need to be clear what the legal basis is. The subject of the data has certain rights. These rights depend on the legal basis. Some of them apply always, some of them apply depending on the legal basis that you're using. So you always have the right to be informed of the data processing. You always have the right to access you. So you can ask your data processor or data controller what they're using the data for, and they have to explain it. And you have the right to rectify data. So if there's a mistake in the data, you can ask them to correct it. You have the right to erasure in some cases. You have the right to restrict processing, the right to portability, so to take your data from one place to another. You have the right to object, and you have rights related to automatic decision-making and profiling. Now, these rights, as I said earlier, depend to some extent on the legal basis you use for the processing, as you can see from this slide. So depending on the legal basis, some rights apply or don't. So you see in the first column here, the different legal basis, and then you see in columns 2, 3, and 4, whether the right to erasure, portability, or object applies in a particular case or not. And you can see that there's quite significant differences. So if you process the personal data on the basis of consent, then the data subject has all the rights available. They can withdraw their consent at any minute, therefore stop providing the data, but also withdraw the data. They have the right to portability and erasure. Whereas if you look at legal obligation, that's where the data subject has least rights. None of these other rights apply to them there. As you might well imagine, if you think about the police collecting data on criminals, they don't have a right for that to be erased. They don't have the right to take it away with them, and they can't object. Right? So you need to keep in mind what the legal basis of processing is in order to make sure that the data subjects have the rights that they should enjoy. If you infringe, or if an organization infringes the GDPR, then there are significant penalties attached to this. You may remember the AI Act that we talked about in the last lecture, where it was 7 million and up to 35 million, so 7% of the global turnover and up to 35 million. GDPR is a bit lower, but it's still 4% of the global turnover and 20 million euros, whichever is higher. So it can still go into the billions. So this is for the most severe violations. For lower level violations, there are lower level of penalties. For an organization, it's often not so much the money that's the problem, but it's the reputational issue. So if you, as a company, as an organization, breach the GDPR or data protection principles, then the problem is typically that your users, the people, your data subjects, will lose trust in you, will not work with you anymore. That, for many companies, is a bigger threat than the actual sanctions in terms of fines from the GDPR. So one of the things that you can do in order to comply with the GDPR is to do a data protection impact assessment. And I actually expect that I will find a lot of references to data protection impact assessments in your group reports, in your action plans for your company. So a data protection impact assessment is a process that identifies and evaluates and mitigates privacy and data protection risks arising from new projects, new systems, new technologies. That may be an upgrade from something that already exists, or it may be a completely new system. So if you do that, if an organization brings in a new system which may raise risks, then they have to do a GDPR. So according to the UK GDPR, the DPIA is mandatory when the data processing is likely to result in high risk to the rights and freedoms of the individual. Examples of that, where this is often the case, is where you process a lot of data, especially special category data, health, religion, and so on. You definitely need to do a DPIA. If you want to use data for automatic decision making, for example, when you do credit scoring, so a lot of the things that are highly contentious in public debate, hiring algorithms and so on, these call for DPIA. And if you do large-scale monitoring, facial recognition, and so on. These are top-level risks. There are a lot of risks that are not quite as obvious, which also call for DPIA. If you don't know whether you need to do DPIA, go to the Information Commissioner's website, where there's a lot of information on the principles and practices of that. So how do you do that? It's a four-step process. It starts with the description of the processing, where you talk about what is the scope, what data is used, how is it, where does it go from where, what is the purpose. So you map your data, you document everything that happens in terms of collection, storage, processing, and so on. You then look at whether it's necessary and proportionate. So do you actually only collect the data you need to do? What's your lawful basis? And is it justified, or could the same purpose be achieved with less personal data? Third one then is the risk identification and assessment, where you look at what the risks are, be that unauthorized access or different uses of the data or biases, and how significant they are. And you model your threat, trying to figure out what exactly the vulnerabilities are and how to deal with them. And then finally, you look at, have I mitigated those risks? So for example, this might be through privacy enhancing technologies. It might be through anonymization of the data. It might be whatever it might be. And then if you're happy that the risks are mediated, you can sign it off. If necessary, you will need to implement whatever measures there are, security protocols, or encryption or access limitation to reduce the risk. If you do a DPIA and the DPIA comes to the conclusion that you cannot adequately mitigate the risks, then you cannot simply go ahead and deploy your system. You then need to consult with the Information Commissioner's office which is the regulator for data and data protection, before proceeding. Now that's important. If you don't do that, you may well be falling foul of the GDPR. There are lots of examples of that having happened. And the data protection authorities in Europe are actually quite happy to go after the big companies. You see here 3 examples of Meta, Amazon, and Uber. And I think if you do a Google search today, you'll probably find a lot more. So this is a piece of legislation that has serious consequences for organization. And just put yourself in the shoes of the developer who did whatever they did in Meta that led to a fine of 1.2 billion. That is not very conducive to your career. I want to quickly touch on the Privacy and Electronic Communications Regulation because it also is relevant to you as computer scientists and professionals. It may very well also be relevant to you in your group project. So this is a local piece of regulation that sits alongside the GDPR and gives people specific rights with regards to electronic communications. So that has rules on marketing calls, email, text, cookies, communication services, and customer privacy with regards to location data, billing data, identification, and directory listings. And the consequences of that we all encounter all the time. So there's the cookie consent. Whenever you go to a website, you now have to consent to the use of cookies. Right? That comes from this piece of regulation. There is, in terms of electronic marketing, is an opt-in requirement. So you shouldn't get unsolicited email trying to sell you stuff. And there should also be an opt-out available. This covers telephone marketing, which is now regulated. It covers security obligations, where telecoms provider must ensure confidentiality. And this whole thing can, again, be enforced. So the fines for breaching this aren't quite as substantive as for GDPR, but still up to £500,000, which is a significant piece of money which companies would want to avoid having to pay. So the point here is that we have the GDPR as a big ticket regulation, but there are other bits of legislation, such as the Privacy and Electronic Communication Regulation. So with that, I will close this session on the law and computer ethics and professionalism. What I think, and I hope you will have learned throughout those 3 lectures, is that there's a lot of law out there. A lot of it is applicable to you. You will not be expected to be an expert in all of this law, but you will be expected to recognize when law becomes relevant to you, and you will have to highlight when that's the case. If you work for a big organization, they will have legal departments, they will have support, but somebody's got to alert those. And that is going to be your job. And you will also need to demonstrate in your group project your understanding of this legal landscape and how you can identify relevant pieces of legislation and how you can deal with them. Thank you very much.